everybody, and welcome to, as far as I can tell, the 156th day of social distancing. It's a new normal we live in. I thought this was going to be a passing fad. For those that don't know me, my name is Mark Alley. I'm the National Market President. I oversee both sales and service in the national footprint for Alerus, which includes all 50 states and approximately 6,800 plan sponsors and 400,000 participants. I will keep my comments brief. I don't want to cut into Brad Campbell's time today. Today's topic is both timely and relevant, dealing with issues that will affect all of us over the coming months and years. For those of you that haven't heard Brad speak before, he does a great job. He's extremely knowledgeable, and you're in for a treat. First and foremost, I'd like to welcome you and thank you for taking the time out of your busy schedule to attend. I see a lot of existing partners and advisors' names out there that we've worked with, as well as some new names. For those of you that are unfamiliar with Alerus, just a brief introduction. At Alerus, we believe that our purpose is to help you achieve yours. We go beyond typical 401k, HSA, payroll record keeping to provide advisors and plan sponsors the tools they need to help participants find their path to financial success. Many of our clients come to Alerus because they were tired of coordinating multiple vendors for employee benefits. Others value our service model, consisting of named dedicated administrators, retirement specialists assigned to each plan and advisor. Still others were simply looking for a partner to provide employee benefits, making them easier, less expensive, and while driving results for participants. If any of these sound familiar to you, please feel free to reach out to one of our dedicated retirement consultants after the presentation today to learn more about what is new at Alerus. Without further ado, I could not be more honored and humbled to be co-sponsoring this event with Federated Hermes. Federated Hermes has been a long-time friend of Alerus and consistently provided not only solid investment performance for advisor and client, but also great thought leadership in portfolio construction, asset allocation, and legislative updates in the defined contribution marketplace. With us today from Federated Hermes is Tim Mercedes, Senior Vice President of Defined Contribution Investment-Only Services. I consider Tim both a friend and a great partner in business. Without further ado, please welcome Tim Mercedes.
Well, good morning, everyone. My name is Tim Mercedes. I'm a Senior Vice President and Senior Retirement Consultant with Federated Hermes, covering the Central United States. I'm a member of a 5-person team of DCIO retirement specialists who work with financial professionals and plan sponsors in the DC space to provide investment solutions and retirement resources. For those of you familiar with Federated, you may have noticed we recently changed our corporate name to Federated Hermes. This is based on an acquisition that we made a few years ago of London-based money manager Hermes Investment Management. We're currently experiencing a record year in sales with total managed assets now at $629 billion. So these are indeed exciting times at Federated Hermes. We're pleased to partner with Alerus today on today's call to provide Brad Campbell. Brad is the former Assistant Secretary of Labor for Employee Benefits under George W. Bush, and he's now a partner with Faegre, Drinker, Biddle, and Reed. As we all know, the DOL has been quite busy this year. In fact, I received just an email this morning that the DOL unveiled a new lifetime income disclosure rule just today. So the DOL has been very busy, and we're excited to have Brad on today to share his insight and information on these topics. It's my pleasure to introduce the Honorable Bradford P. Campbell. Welcome to today's call, Brad, and on behalf of Federated and Alerus, thank you for joining us.
We have Brad Campbell.
Mark, this is Mary. It looks like we had just a moment trying to unmute Brad. I was unmuting him earlier. Hold on just a minute. Let me
until you can hear me. Can you hear me now?
Yes, Brad.
Okay, good. Well, the good news is that gives me a chance to do better the second time. All right. Well, what I said was, thanks, Tim, and thanks to the folks at Alerus and Federated Hermes for getting together, but more importantly, thanks to all of you for taking the time. We want to start on the first slide here, the whirlwind of regulations slide. And really what's kind of been happening is while DOL certainly has been up to doing things and has, done a number of things over the last 3 years, we've got the safe harbor for electronic disclosure now as a new alternative. We went through all the fun with the fiduciary rule of being delayed, then partially implemented, then vacated by the Fifth Circuit. But the reality is DOL has a lot of things on its agenda that it hadn't gotten to yet, and it decided to do all of them now. And so what we have is a situation where there are a boatload of new rules that have just been proposed and several more in the offing. And so I thought we'd start out by just running through a couple of those. Now, first of all, why is DOL putting everything out the door right now? The answer is pretty simple. They want to make sure that their agenda gets enacted before the election because there's obviously uncertainty as to what's going to happen in the election. We don't know who's going to win. But what we do know is that if the Trump administration puts out regulations, final rules, and those rules are published in the Federal Register more than 60 days before the end of the administration, if there's not a second term, then those rules will be good. They'll stick. They'll be part of the Federal Register that most likely can't be changed unless there's additional new notice and comment rulemaking. Now, there's a couple of exceptions to that. If the Democrats were to win the House and the Senate as well as the White House, they could use what's called the Congressional Review Act, and they could invalidate regulations going back farther than 60 days because it's based on legislative days. So 60 days Congress was in session, and you'll be shocked to learn that Congress doesn't meet on a daily basis. So 60 legislative days is more like 6 months. Anyway, the point is, in order to ensure their agenda has the greatest chance of surviving if they lose the election, the Trump folks want to get these rules finalized before November so that they'll be on the books long enough to be valid rules. And here are the big ones that they've got in the offing. As you all probably already saw, they put out a new rule on ESG investing. The comment period for that closed at the end of July. They received something on the order of 8,000 or 9,000 comments. It was quite a popular rule in terms of comments. Almost all of those were taking kind of a dim view of what DOL wanted. And we'll talk in a minute about exactly what DOL proposed. The other big one that came out, and the comment period just ended here in the first week of August, is the new fiduciary rule. And we'll talk in some detail about what that proposes as well. This is sort of the response that DOL finally 2 years later is giving us to the Fifth Circuit having vacated the 2016 fiduciary rule. So it's different in that it's the Trump administration, obviously, not the Obama administration, but it also has a lot of similarities, and we'll talk about those in a minute. The one that as Tim was saying, just came out today is the lifetime income provisions that are required by the Secure Act. So this is getting into the new rule requires that participants get on an annual basis a projection of what their account balances would be in terms of generating lifetime income. And while this is conceptually something that's been something people I think have been open to for quite a while, and it was obviously popular and Congress passed it on a bipartisan basis, technically, it presents a lot of issues. And so one of the things we're going to be looking at in the proposal that DOL just put out is exactly how are they addressing some of those technical problems. And we'll talk about some of those in a minute. There's two more big ones that are about to come out that we don't know much yet about because we haven't seen them. One is the Secure Act pooled employer plan rules. DOL has pending at OMB a rule that would, meaning it's under review at the White House, a rule that would implement some of the pooled employer plan provisions of the Secure Act. And there's a lot we don't know about what this rule is going to do. Is it going to be a very narrow implementation rule? Is it going to have broader provisions that allow things that people have been asking for but that aren't clearly allowed by the statute? Will it provide new exemptions to allow, for example, the folks who are running the PEP to also make discretionary management decisions about their own products? A lot of questions like that that we're waiting for answers. And we'll talk a little bit about pooled employer plans in a minute too. So we're waiting to see what DOL is going to do there. The last one that you should be aware is in the offing is, oh, and by the way, I should say that PEP rule has been approved by OMB, but not yet published. So we'll probably see that in the next week or two. The one that's still at OMB under review, so it's the last one probably that'll come out, is this new rule on proxy voting. And we don't know what's specifically going to be in this. It was kind of a surprise rule in that it wasn't on the fall agenda. DOL puts out a spring, well, the entire federal government puts out a fall and spring agenda that says what rules they're going to work on in the next 12 months and when they're going to happen. Now, that often proves not quite to be accurate, but at least that's what they generally do. The fall agenda that came out last November 20th did not include this proxy voting rule or the ESG rule. So both of those are things DOL dreamed up, wrote, and published in basically 5 or 6 months, which is a really fast time period for regulations. What we think this proxy voting rule is going to be about is trying to make it harder for ERISA plan assets, both DB and DC, to be used in connection with shareholder activism. In other words, they'll probably be similar to an interpretive bulletin that we put out in 2008, back when I was running EBSA, that said, you know, you can't be subordinating the interests of the participants, you can't be spending their plan assets to pursue a bunch of initiatives as shareholders that aren't going to have, aren't likely to have a real economic impact. So an example from that old guidance was, if this whole proxy voting is about, you know, making board members disclose their political contributions, that's something that would be unlikely to have any financial impact on the company. Therefore, the plan shouldn't spend money on evaluating and voting and helping with those types of initiatives. So it's probably something on that variation. What it probably will require, assuming they finalize it, is that advisors have conversations with their plans about what their proxy voting policies actually are. And I suspect that's probably an issue that, while you may have discussed with plans recently, probably not been on the top of a lot of people's lists. So if this rule is finalized, and of course, depending on what it actually says, that'll probably be a topic that we're going to have to address with clients coming up. All right, well, let's move on to the next slide here. So the next slide is a little quick hit meaning coverage, not making any political statements, of what Vice President Biden has released about sort of his plans in this area. And there's not a whole lot of detail here. One of the concrete proposals on retirement, which, just so you know, is to eliminate the earnings cap on Social Security. In other words, you would pay Social Security tax under his proposal up to whatever you earn, not capped off at I don't know, 137,000, whatever the current cap is. And he has some unspecified changes to Medicare and Medicaid that would make those programs allegedly more financially secure. In terms of our area, the Vice President's been proposing a form of an automatic 401k or IRA. This would be similar to what we've seen in Illinois. Well, we presume, we don't have any details, but the concept would be a federal version of what we've seen in Illinois or California or Oregon, where there is a payroll deduction IRA established in those states that employers who don't offer a plan, an ERISA plan, have to offer their employees instead. So that's presumably something that he would be pursuing as a matter of federal law and regulation. He's also proposed increasing the contributions to make catch-up contributions for folks who took time out of the workplace to be caregivers to family members. And in one that's probably the least amount of detail but kind of the most intriguing is he suggested that our current tax setup for ERISA plans, for example, favors those who have income to defer. Their thesis is that lower income workers can't afford to save for retirement. Therefore, the benefits of our current retirement system inure more to more highly compensated folks. And so he wants to equalize benefits across the income scale. And we don't really know what that means beyond that. There's also a whole bunch of speculation about what would be the broader financial regulatory goals of a Biden administration. There's statements in the president in his platform without identifying it by name that suggest they would be looking to eliminate regulation best interest on the grounds that it isn't a fiduciary standard, and presumably look to harmonize in the sense of require a uniform fiduciary standard. It looks as though they might be interested in pursuing some additional stronger variation of the DOL fiduciary rule from 2016. And I think one of the things everyone's looking at is trying to reconcile how if there is a Biden administration, how they would regulate in the financial services area. Would they be more, as Vice President Biden himself has been traditionally, more moderate on financial regulation, or will folks like Senator Warren and Senator Sanders have a large role in a Biden administration in regulating financial services? One common area of speculation is, would Senator Warren be the new Treasury Secretary? Would their staffers and proteges become SEC commissioners? There's all of those types of questions that people are thinking about. So what we have here, just to sum up kind of the political part of this, is we have the Trump administration desperately trying to finish its agenda by throwing all their rules out the door with very short comment periods. And frankly, I think, as we'll discuss here in a minute, not always some of the best policies because they're not taking the time to have fully thought things out. But then we also have the uncertainty of the election with some pretty big policy differences where President Biden, if he is a president, if he becomes president, would have some pretty different ideas here about financial regulation more generally, perhaps less so per se in the retirement plan space, but certainly a lot in the regulation of advisors. So with that, let's dive into a couple of, well, actually, this is really a good place, Mary, to stop and see if we have any questions about these big picture things before we jump into a little more granular review of the fiduciary rule and the ESG rule and so forth.
Yes, thank you, Brad. Appreciate it. There are no questions as of now in the Q&A, but thank you for checking.
Okay, great. Well, then let's plow on to the next slide, which is about the ESG rule. And the reason I think this is important is a couple of reasons. One, the Labor Department, the press really got a lot of the coverage of this rule wrong. When the rule was proposed, a lot of the headlines made it sound like, gee, you can't, ERISA plans aren't supposed to be involved in ESG, DOL is anti-ESG. And I think that's not actually what the proposal did, and to the extent it had some troubling provisions, and there were a few in there for proponents of ESG, they got a lot of comments on those. So I think really here, as I say in the slide, it boils down to 5 big issues. First of all, this does not ban ESG from ERISA plans. What it actually does is give you a roadmap for how to do ESG in ERISA. This is all about, this proposed rule is really all about what is it fiduciaries should do in evaluating ESG investments. And this isn't a new issue. DOL first issued guidance on ESG, although they called it something else, but on ESG investments back in 1994 in the Clinton administration. We put out guidance on it in 2008 in the Bush administration. The Obama folks put out new guidance on it in 2015. The Trump folks put out some guidance in 2018 interpreting the 2015 guidance, and then finally decided they wanted to do a new regulation. So the big change here is we've gone from guidance to regulation. It's important to understand the rule specifically allows ERISA plans to select ESG-related investments as core menu items, as designated investment alternatives. But they have to be prudent. In other words, you're not waiving any of the normal requirements for ESG investments. You're making sure that these investments would screen as would any other investment through your normal process. And if you go through that, then ESG investments are perfectly appropriate for plans, and the proposed rule specifically says that. Where the proposed rule tries to draw a distinction is to say that, ESG issues could be pecuniary, meaning that they actually are relevant to the economics of the investment, or they could be non-pecuniary, meaning that these are social goals that may not translate into better investment performance or reduced risk. And so what DOL has said is, look, ERISA is about making money for people's retirement. The fiduciaries of an ERISA plan can't go out and try to, do good if it means you don't do well. So you can't select an investment as a fiduciary where the ESG factors are the primary consideration such that you would accept increased risk or reduced returns in order to achieve the ESG idea. What you can do is say, okay, well, we're looking at ESG factors as metrics that help us evaluate investments with a goal towards reducing risk, with a goal towards increasing performance, i.e. these are pecuniary factors. We want to be integrating some of those factors into our investment analysis. And I think this is where DOL's sort of is lagging behind the marketplace in understanding what ESG does. I think they're still operating under the assumption that a lot of ESG investing is about, investing in something because it's going to do good and not as concerned about the results. Whereas the reality is most of ESG investments today are using ESG factors as part of this pecuniary analysis. The generally accepted investment theories employed by investment professionals, as DOL puts it, are looking at it and saying, well, we're finding a correlation between better performance or diversified risk, or name your other factors that are important, where we're seeing that companies that do well on ESG ratings are also doing well financially. And so there's correlations that we want to use these factors to explore. That type of integrated approach to ESG is consistent with what DOL has proposed here. The big controversy and the big thing DOL did in this rule that is sort of anti-ESG is they said, even if we've said you can use ESG as core menu items, but if you're using a fund that is ESG themed in its investment mandate or that has an ESG theme in its title, then we don't want you to use that as a QDIA, so an automatic enrollment, a default investment, and we don't want you to use it as a component of a QDIA. And that restriction got a lot of comments in opposition saying to DOL, well, you haven't explained why, if it's prudent to have this as a menu item, why would it be imprudent to have it as a default menu item, assuming it otherwise meets the requirements of the QDIA rule? Either it's prudent or it isn't. And DOL didn't really do a good job of explaining what their objection was, other than saying they felt it was different for people to have an affirmative choice, that they could select an ESG-related investment as opposed to being defaulted in one where they didn't affirmatively choose. So stay tuned on that. As I said, there were thousands of comments, and DOL is going to have to sort through those to come to an answer on what a final rule looks like. Do we have any questions on ESG maybe before we continue on to the fiduciary rule?
Yes, Brad, thank you for checking in. There are no questions yet in the Q&A. So, and just as a reminder to everyone, you can hover at the top of Brad's presentation to open the Q&A icon, and that's how you can submit your questions. Thanks, Brad, for checking.
Okay, and to the audience, I apologize for this sort of more tedious way of doing it, but it's because of the technical difficulties. I'm just on a phone line, so I'm not seeing what you're seeing, so I can't tell whether there's questions there or not. All right, so let's go on to the next slide, Fiduciary Rule 3.0. Now, I know we said 2.0, and in many respects that's true, but technically DOL did have a proposal back in 2010, 2011 on the fiduciary rule. So really this is 3.0. DOL's really done something unusual here that we didn't expect. There's two parts to what they did on this fiduciary rule. One part's expected, as much as we expected, the other part's a surprise. The part we expected was a new class exemption. So what this means is they're putting out a broad-based set of conditions that, if you meet them, permit reasonable compensation in a whole bunch of forms. So you could get commissions, you could get transaction-based compensation, you could get flat fees, you could get third-party payments, 12B1 fees. basically a whole host of otherwise reasonable amounts of compensation would be allowed, provided you met the conditions of the exemption. And this is useful because there's a whole bunch of scenarios where little tiny differences cause problems under ERISA, even though they don't practically have any material effect on advice. I'll give you an example. Even for those of you who are 100% flat fee-based RIAs, let's say, so that you don't have what DOL might otherwise consider conflicted compensation, because generally DOL's taken the view that flat fees are not conflicted. One can debate that, not trying to start a debate about that, but that's just DOL's traditional position. They have, however, DOL taken the position that in a rollover scenario where you are recommending to a participant in a plan either you have a relationship with or to a new client that you don't previously have a relationship with, DOL has said, well, even if you're a fee-based advisor with a flat fee, the actual rollover recommendation is a conflict of interest. It is a prohibited transaction because your fiduciary advice that they do the rollover is causing you to either receive new compensation or to receive different compensation. So the idea is if a participant in your plan that you're a fiduciary to comes to you and says, hey, I want to retire, I want to do a rollover, I've gotten to know you for the last 10 years, will you help me? And you say, yes, I'll help you. Let's talk about whether you want to do a rollover. I'll recommend whether you should and where you should go and all of those issues. If that is fiduciary advice, and we'll get to that in a second, but if that is fiduciary advice, then it is a prohibited transaction in DOL's view because you're influencing your own compensation. So it's not, and so my broader point here is this exemption is not just for, commissions, it's for a whole host of various prohibited transactions related to fiduciary investment advice. And so this proposed exemption is actually pretty helpful. The concept is a good one. It would be very helpful to have an exemption that we can generally use. And what DOL's done is to say, well, we want to be efficient in how we're going to regulate this stuff. And we know the SEC has the new regulation best interest, which has, conditions now that a lot of, the broker-dealers are meeting. What if we take our conditions and harmonize them to the extent possible with the SEC so that if you're, for example, a registered rep of a broker-dealer, what you're already doing for Reg BI would count largely towards what we would require under ERISA. In other words, it would give you kind of one-stop regulatory shopping. So to that extent, this new proposed exemption is modeled on Reg BI. You have to make a best interest recommendation, and the language they use for that is basically identical with what Reg BI says about a best interest recommendation. You have to give no materially misleading statements. You have to charge reasonable fees. There is a policy and procedure that the financial institution has to adopt to ensure that there are that advisors don't act on conflicts of interest. There's a retrospective review that has to be undertaken. That's a little different than Reg BI. And unfortunately, it also requires you to acknowledge up front that the investment professional and the financial institution are fiduciaries in order to use the exemption. So the comments that came back on that portion of it were generally supportive of the concept, but recommended some changes in its execution. Things like saying, we're not necessarily sure in that first conversation whether we're a fiduciary for ERISA purposes. So let's not have this require us to state we are. Instead, let's let this exemption be used without that direct statement. This retrospective review is a new concept that people objected to. In other words, the comments that came in said, we like your idea, we want a broad exemption, we like the idea of harmonizing it with securities law so that we reduce the amount of effort it takes, separate duplicative requirements, but we have some changes we want to see. That was the security side. The insurance side said, well, we appreciate that you're trying to do that, but it sure would be nice if you had a parallel insurance regulation like the NAIC model rule on annuities that we could copy. In other words, that compliance with that would be substantial compliance with this new exemption because we aren't subject to best interest when we recommend insurance products that aren't securities, and therefore it's a fundamentally heavier lift for us to get to the same place. All that DOL is chewing on, we'll see how they actually make changes to the exemption that they've proposed. But generally speaking, I think most folks have looked at it and said, if you fix a few of the problems, we like it, that meaning financial services industry. Consumer groups have said it has the same weaknesses as Reg BI and have attacked it. The other half, and this is the part that was very controversial and pretty much universally among financial services companies, advisors, insurance agents, you name it, everyone really had some problems with, is the unexpected part, the part where DOL said, hey, we're also going to reinterpret what rollover means. and this is really kind of surprising from the Trump administration. So they said, look, we're not going to change the 1975 regulation. This is, the 2016 rule that DOL put out in the Obama administration was struck down by the Fifth Circuit. The effect of that was the old 1975 regulation was reinstated, and it has a 5-part test for when you're an ERISA fiduciary. Those 5 parts are you giving individualized advice for a fee, subject to a mutual understanding that this advice will be a primary basis for the plan's decision-making, and are you providing that advice on a regular basis? So those are the 5 parts that are in the 1975 regulation. DOL is not proposing changing any of those 5 parts in terms of the words in the statute and the regulation. They're leaving the words in the regulation alone. What DOL is proposing to do is change what they think those words mean. So this new guidance that they announced in this proposed class exemption, and to just explain the difference, the guidance is already effective. It's not a notice and comment rule. It's just DOL announcing that it has changed its mind about what it thinks these words mean. So it's been in effect since, June 29th. And that's part of the concern here is essentially they are rewriting the 1975 rule through a new guidance interpretation without changing the words. So they're trying to have it both ways. They're trying to say, no, we're sticking with the rule that the court liked, but we're now going to say it means the opposite of what it used to mean. And that, I think, has raised a lot of concerns. A couple of the areas that have particularly raised concerns are their new view of regular basis and the other 5 elements in connection with rollover recommendations. And so there was a 2005 advisory opinion that stated categorically that most rollover recommendations are not going to be ERISA fiduciary advice under the 5-part test. In the guidance, DOL has rescinded that advisory opinion and replaced it with this new guidance, which has the result of us not really being sure where DOL thinks the line is drawn on rollovers. And let me give you an example of specifically on regular basis of what they're saying and why this is causing confusion. So they're suggesting that a regular basis, in other words, that you're regularly providing ERISA advice, is met in a one-time rollover advice scenario in an anticipated ongoing advice relationship. So this is the scenario. You sit down with a new client you've never talked to before, and you recommend that they roll over from their 401k to an IRA. Even though you've only met once to have that rollover recommendation, because both parties anticipate and intend that they will meet again in the future to provide more advice once the rollover has occurred, DOL has said that satisfies the regular basis test because there is an anticipated ongoing relationship. Now, personally, I think that's just ridiculous on the face of it. They're effectively saying even though you've only met once, it qualifies as a regular basis because you plan on meeting again. We'll see what happens if they actually try to bring an enforcement action under that theory, but I think it's very likely to be challenged. The other thing they created was the ongoing basis test, which says, okay, this isn't the first time you and I have talked, but what I've done in the past was recommend securities or other financial instruments separate from ERISA. But because we've met in the past on several occasions about these other securities or financial instruments, the first time I provide you this rollover recommendation, it meets regular basis because even though we've only met once on ERISA, we've met more than once on other issues. And I think that also raises a lot of questions because recommending a security or recommending a financial instrument isn't the same thing as being an ERISA fiduciary. And that was the whole point of the Fifth Circuit ruling, was that there's a special relationship of trust that comes with being an ERISA fiduciary that isn't conveyed by a mere sales transaction. So the bottom line is we have this new guidance coming out of DOL about expanding when rollover recommendations are fiduciary that have reintroduced some of the questions and problems from 2016, but without some of the answers. So a lot of the comments that went back to DOL dealt with, hey, you've got this wrong, we don't understand where you're going, this doesn't work, we need some new answers. And that's what we're waiting to find out. The comment period closed on July 6th. We're now waiting to see what DOL is going to say about it. Very briefly, let's just hit the last couple of issues. Pooled employer plans, this is something I think advisors need to be aware of and pay attention to, but it's not at all clear how it's going to work. So if we move on to the what is a pooled employer plan slide. Basically what it's allowing is, I'm sorry.
Brad, sorry to interrupt. We do have a couple of questions in the Q&A. Would now be an okay time to ask those?
Yeah, let's do it.
Okay. All right. Well, Frank actually had a question about the ESG. He said, could you please weigh in on the aspects of the ESG? Is there one which is more important than the other when considering adding an ESG investment to a lineup?
Yeah, so, the issue here is what's pecuniary and what isn't. And in terms of adding it to the lineup, I would say the primary things you should consider are, would this investment pass my normal investment screens? So independent of the ESG factors, is this investment going to be prudent under my normal process? And if the answer is yes, then you're in pretty good shape from a fiduciary perspective. So in terms, though, of if I'm looking at ESG factors, which ones are more important? Well, I guess I would say some of the governance issues are obviously going to be pecuniary. If you have a dysfunctional corporate governance structure, that's a factor any investment manager, whether they're ESG or not, is going to consider. Similarly, some of these environmental factors. If this is a company is in an industry that pollutes, it's just a natural byproduct of what that industry does, then that's going to be relevant because regulation of pollution, the risks of different government actions, environmental risks in terms of litigation claims, all of that is material pecuniary interest to evaluating that investment. So from a fiduciary perspective, I really think rather than try to get in and weigh the fine distinctions of which ESG factors are more important and which aren't, for a plan advisor, I think the key is looking at this investment, will it pass my normal screens? If I go through my normal fiduciary process, would this investment come out the other side as one of the prudent options? I think it's important to remember that, your prudent investment process typically doesn't generate one answer. It typically generates several or more investments that would be appropriate for a particular slice of your portfolio. The ESG factors can be useful in distinguishing between those. So let's say there's 4 funds that have come out of your review process that meet all the requirements that you have in the normal process. You could use the ESG factor as a tiebreaker to suggest, well, I think I'll pick this one. All 4 of these are prudent because they've come through my prudent process, but we can pick this one because there's a favor, there's a reason that distinguishes this one. That's consistent with the current DOL guidance. The new proposed rule suggests that a tiebreaker is for economically indistinguishable investments, where they seem to be focusing on whether the 2 investments are quote unquote equal. I would argue the correct answer should be, are they both prudent, and distinguish between that, but that's not quite how the proposed rule reads. The upshot is, if you're following a prudent investment process and these investments come through, you're in good shape because you've selected them for normal pecuniary reasons. One common thing advisors can look at for cases where plans want investments that aren't going to pass that prudent process, one common way you can address that is with a brokerage window, which would allow individual participants to have access to whatever it might be, ESG investments, Sharia-compliant investments, biblically based investments, things that may not pass your normal process, could be available in a brokerage window where the plan has not selected them as DIAs, and it gives participants access without having that fiduciary affirmative imprint on it. So that's a common way I think a lot of advisors can address cases where ESG isn't going to be compatible fully with the ERISA requirements.
Great. Thank you so much, Brad. And we did have one more question before we move on. This question is from Mallory. She asked, should fiduciaries reevaluate their investment policy statement given the new ESG guidance from the DOL? And if yes, what items need to be changed or included?
Yeah, that's a great question. I personally would not yet make any changes to my investment policy statement based on this proposed rule because it's just a proposal. We don't know how it's going to change. We don't know what the final rule is going to look like. The most obvious thing that DOL did in the proposal that would potentially be something you need to put in your investment policy statement would be if they retain this prohibition on using certain types of ESG as QDIAs. That's something you're going to want to make sure you've covered because obviously, we want to make sure the plan complies with those requirements. I personally am hopeful that DOL is going to change that QDIA provision substantially because at the end of the day, if an investment's prudent, it's prudent. It shouldn't be a problem to use it as a QDIA or a DIA. And DOL certainly didn't make the case, in my view, in the proposal. They didn't make the case for why they had that restriction in there. So we'll see what happens. My advice is, at this point, as long as your investment policy statement provides a good, prudent fiduciary process for all investments, continue with that and wait on making any changes until we see whether there's a final rule and if so, what the final rule says. Any more questions, or should we plow on to PEPs?
Fantastic. No, all good. Let's move forward. Thank you, Brad.
Okay. So again, PEPs was in the Secure Act. It's potentially a big change, but what we don't know is, will it turn out to be a big change? And I think that's the million-dollar question everybody's wondering. I've talked to a lot of folks who are in the process of putting together PEP options. And again, what it is where you're bringing together a bunch of otherwise unrelated plans. They become participating employers in a single plan with a single 5500 and a single audit. The obligations of the employers are largely to approve the arrangement and the compensation for the professional manager of the arrangement, which is the pooled plan provider, or PPP. The participating employer has to be a fiduciary for approving the arrangement, reviewing the compensation. It can be structured so they can make investment decisions, but their primary responsibilities are approving the engagement and sending in the money to participant contributions on time. The rest of it is handled both, the investment functions, the 316 functions are largely handled by the pooled plan provider. And there's a lot of flexibility actually in the statute as to how that could be set up. It could be an advisor who's, working with a TPA. It could be big financial institutions that are white labeling these the back office services so that advisors or TPAs could put it out as their own sort of plan that members can join. There's just a lot of different ways it could be structured. And as we've talked to folks who are looking at it, I'm getting kind of two very different perspectives of how these are going to work, if they're going to work. One set of folks I've talked to are really excited about PEPs. They think they're going to be the next big thing. They think they're going to really appeal, particularly to small businesses and to folks who are right around that 100 participant cutoff for doing their own audits under the 5500. They think it's a big market. I've talked to others who are saying, well, we're probably going to put together a product because we think some advisors or our distribution partners want it, but we don't see where there's going to be cost savings. We don't see where it's going to be a big deal because at the end of the day, you're still having to record keep a bunch of small entities who have separate payrolls, and we just don't see the economies of scale. But what we don't know is which one of those views is going to prevail in the marketplace. What we also don't know is what the regulatory environment's going to be. I mentioned we have a pending regulation from DOL. We don't know what's in it yet. We don't know whether financial institutions that manufacture investment products, in other words, insurance companies, investment companies, banks, are they going to be able to use their own products in these PEPs? And if the answer to that is yes, maybe that sets up one set of conditions. Currently, the answer is probably no. at least as directly constituted, so that's a different set of issues. The bottom line for advisors, I think, is you need to be aware of what's happening with PEPs and look around the marketplace and see, because there's really three outcomes, and I know this sounds kind of stupid to say it, but the three outcomes are this could be an opportunity for you, this could be a risk for you, or this could be irrelevant. And literally any of those could be true, but they could be true differently for different advisors. So if your market is all small plans to whom you're providing substantially similar services, then maybe this is something that potentially faces a risk. If your market is customized plans that have specific requirements, and I apologize for the dog there, apparently we're getting a package. If your market is plans that have a lot of specialization that really want to run their own thing their own way, probably this is irrelevant to you. Because it certainly appears that when the first PEPs go online next year, they're probably going to be very limited options. The old joke, as Henry Ford said, you could have whatever color Model T you wanted as long as it was black. That's probably true of a lot of the early PEPs, simply because they're going to need to have some commonalities to get them off the ground and make them financially viable. So bottom line on PEPs is I would pay attention to it, but it's not at all clear whether this is actually going to work the way it was intended, and it's not at all clear the different ways it's going to be distributed, because we have both market forces that are going to sort that out, but we also have regulatory forces that have yet to weigh in. And if there's a change in administrations, there's even more uncertainty, because regardless of the policies that a Biden administration, if there is one, would put in place that might differ from the Trump administration, the fact that there's a change is going to slow everything down. So January of next year, if the Trump administration leaves and the Biden administration comes in, the incoming administration is likely going to put a stop on all the regulations till they figure out what they are, which ones they like, which ones they don't, what they want to do instead. They have to hire their new people to run the agencies, new secretaries of labor, new assistant secretaries. All that takes time. So if there is a change in administrations, the regulatory side is going to lag just by the nature of how that process works. The last thing, we'll skip over the Secure Act things because, that new regulation just came out. We need to read it and find what's in it. I do want to mention this one last point before we see if there are any more questions. What is it that DOL is doing on the enforcement side? The biggest change that we have seen in the last couple of years, and it is a really large initiative for DOL, is dealing with missing participants. So these are folks who are separated vested employees, typically people who've retired from the company but are still participants, and they're entitled to all the rights and responsibilities of participants, even though they're no longer employees. It's pretty common that as these folks retire and start moving around, the plan loses track with some of them. And especially as they get to RMD age, DOL is taking the position that the fiduciary of the plan should have been trying to maintain contact, and if they haven't and people aren't getting benefits, then that's a fiduciary breach. And so these DOL investigations have been, and this has happened for the last 2 years, in every single plan sponsor investigation I've seen, DOL has looked to see what are you doing when you have missing participants, what are the steps you're taking as a fiduciary to reduce that issue, and how is it working. And just to give you a sense of the scope of this, last year DOL had $2.5 billion in monetary results. $1.5 billion was due to benefits of missing participants. So as you can see, this is a huge factor in the agency's enforcement results and therefore in the activity they're undertaking. First step so this is the kind of thing that I think advisors might want to consider bringing up with their clients at the next meeting. Do we have a handle on our missing participants? What are we doing about it? The first step, of course, is talking to your record keeper to find out what they do when a quarterly benefit statement or something like that gets returned to sender. What are you doing about stale checks? Are there a lot of checks that aren't being cashed? Do you have folks who are retirement or RMD age who are not getting RMDs, taking RMDs? These are all things that you should look at, find out how much of that's going on and consider addressing. Steps to take would be seeing if you have another plan like a retiree medical plan that might have a good address, doing free internet searches, but also consider hiring a vendor who would take care of this by looking at credit records, death records. The bottom line is if you are doing something and getting in front of this, you're going to be in a much better position to answer DOL's questions than if you aren't doing anything about it and DOL comes knocking. And if they come knocking, they will ask about this. It's something that they're asking about in every plan sponsor investigation. So with that, I know we're almost out of time. Let's see if there are any other questions or closing thoughts or comments.
Yes, thank you so much, Brad. We did have one question that came in from Mark. He asked, how is reasonable compensation, how is it determined? How is reasonable compensation determined under the fiduciary rule?
Yeah, that's a great point. So for folks who are not commonly in the ERISA space, that sounds like a really bigger, scarier question. For folks who've been in ERISA for a long time, they've known it's kind of always been one of these concepts in ERISA that fees have to be reasonable. A reasonable fee is not the cheapest fee. That's the first point we need to keep in mind. A reasonable fee is based on the totality of the circumstances. So example, when you're hiring a vendor, like a record keeper, a reasonable fee, or an advisor, a reasonable fee would be looking at what is the market rate for those services in the marketplace. So benchmarking is one way to look at it to get a sense. You know, for someone who's providing investment advice services to our plan committee, what is typical for people to be charging for a plan of our size? And then you're putting a zone around that, not a point. You know, it's not a question of, well, this advisor is 1 basis point more expensive than that advisor, let's go with the cheaper one. No, it's about taking into account all the relevant factors. What's their experience with plans like yours? You know, what's the feedback from other clients? If you've had experience with them before, how did that experience go? Were they responsive? Were they not? All of those issues go into it. So a reasonable fee really is based on sort of market prices with a zone around it to accommodate individual variations. So to kind of think of it as, you know, making a football analogy, if the 50-yard line is kind of the average set of fees for something, you know, you can go out to 65, 70 yards probably, you know, 10 or 15 yards either direction, and looking at what's a reasonable fee because it's based on the services that are being provided and the quality related to all that. The analogy I like to use is that if a plan fiduciary, you know, if you were going to hire a contractor to redo your kitchen, you're probably not going to pick the cheapest contractor just because they're the cheapest. You're going to look at whether they show up. You're going to look at what the quality of their work is. You're going to look at, you know, all the factors that go into how long do I want to be without a kitchen while they're doing the work on this, and balance all that with price. And that's really the same kind of analysis that goes into what's a reasonable fee. So for ERISA purposes, it's very much a process market-based determination as really the best way to determine it. And it is somewhat flexible as a result. It's not rigid. It's not pick the cheapest.
Thank you, Brad. Much appreciated. And we are getting very close to the end of our time here. So I would like to invite my colleague Wade Dykema to share some thoughts here at this time. Wade?
Thanks, Mary, and thank you, Brad. That was a lot of really good information, and I appreciate your willingness to share it with us. Good morning, everyone. It's always good to introduce yourself at the end of the presentation. That's where I find myself, and I guess that's one way of preventing me from getting too long-winded, so I'll be brief. At any rate, I'm Wade Dykema. I am the sales director for Alerus Retirement Benefits, which is our retirement benefit administration arm of our company. But I'd like to start by thanking Federated Hermes for our partnership and co-sponsoring this great event. And on behalf of Federated Hermes and Alerus, I'd also like to extend a big thank you to Brad for presenting this morning. And also thanks to all of you who took time from your busy schedules to attend. I know that you get pulled in a lot of different directions, and there's a lot of different webinars and sessions you can attend, and so we don't take it for granted. We're honored that you chose to attend this one with us. With that, we'll conclude the presentation and enjoy the rest of your day, and I hope you have a great one. Thank you.